Good afternoon, everyone, and welcome. My name is Nolan McCarty. I'm the chair of the politics department. It's my pleasure to welcome you to what I think will be a very timely presentation and discussion. After almost a year of a vacancy on the Supreme Court, one that was left open presumably to allow a presidential election to determine the balance of power on the court, which led many voters to cast their ballots not so much on the presidential candidates themselves, but for whom such a candidate might appoint to that ninth position on the Supreme Court and to make subsequent appointments. I think it's a very timely to discuss the politicization of the Supreme Court. So for that, I'm delighted to have with us James Zirin, who in his new book, Supremely Partisan, How Raw Politics Tips the Scales in the United States Supreme Court, argues that the Supreme Court has become increasingly partisan, rapidly making policy choices right and left on bases that have little or nothing to do with the law or the U.S. Constitution. He explains how America arrived at this present situation and looks at the current divide through its leading partisans, Justices Ruth Bader Ginsburg and Sonia Sotomayor on the left, and Clarence Thomas and the late Antonin Scalia on the right. A 1961 Princeton graduate, James is a leading litigator who's appeared in federal and state courts around the nation. He is a former assistant U.S. attorney for the Southern District of New York, having served in the criminal division of that office under the legendary Robert M. Morgenthau. After we hear from James, we'll have a question-answer period when you can ask questions. Also, if you happen to be watching on a streaming service, on our streaming service through the YouTube channel, you can submit questions on Twitter using the hashtag WOO, W-O-O, Lection, L-E-C-T-I-O-N 16. And if you do that through Twitter and hashtag WOO, you will be able to have your question answered. And finally, I should admit, stick around afterwards because there will be a book sale and signing following the discussion. So with that, join me in welcoming James back to the Wilson School.
Thank you very much. It's an honor to be here. It's an honor to be at the Woodrow Wilson School, and it's always my delight to come back to Princeton, where I spent some of my formative years. I'm going to talk to you a little bit about the Constitution, a little bit about the Supreme Court, and a little bit about my book. And I hope that it's certainly timely, but I hope it will illuminate for you some of the issues that are involved. I apologize if I cover things that you may know already or second nature to you about the Constitution, since we're all, particularly as a result of the election campaign, very much involved with what is there, and I'll talk a little bit about constitutional interpretation and how that's played out, particularly in recent years on the court. If and when, I guess when, Donald Trump takes the oath of office on January 20th, he will take an oath which is set forth in the Constitution, which includes the words preserve, protect, and defend the Constitution. And it's a little unsettling because based on some of the things that he said during the campaign and also some of the things he said after his election, one may fairly raise the question whether there's any understanding whatsoever of what is in the document and what it requires, and how it's been interpreted, and what is intended to achieve. Notably, he said during the campaign that he wants to deport American citizens because their parents are here illegally, something which he couldn't do. He has said he wants to exclude Muslims from the country, although he backed off on that somewhat. Said he wants to exclude people from countries that have a record of terrorism. And he said he wants to require Muslims to register sort of a roundup of Muslims on the theory that they must be terrorists or they must be subversive in some way, which resonated with, I suppose, what happened in Germany in 1933, or what has happened during the Second World War with the Japanese internment, which also brings into play the Supreme Court. Since his election, he made the extraordinary comment that he wants to prosecute people that burn the flag, and that he wants to strip them of their citizenship. Well, both things were prescribed by the Supreme Court. In Johnson v. Texas, a decision concurred in by Justice Scalia, it was held that flag burning is protected as symbolic speech by the First Amendment. And it was decided earlier in the Affirmative case that that the government can't strip people of their citizenship as a form of punishment, and that the only way that you can give up your citizenship is if you give it up voluntarily. Now, it seems that he would have someone around him, Mr. Bannon or his counsel, or somebody who would tell him what the Constitution has required, what the court holdings have been. Or does he want to appoint justices to the Supreme Court that will overrule those holdings? And it is highly unlikely that anyone on the present court would vote to overrule the flag burning case or vote to overrule the case on, we call it depatriation, on stripping someone of their citizenship. Nonetheless, he said it. So the question arises whether Mr. Trump needs some education in this Constitution he wants to swear to protect and defend and preserve, or whether he's just going to go on merrily trying to overturn really decades and decades of jurisprudence. Now, these attitudes have carried over to his approach to the Supreme Court appointment to fill the Scalia vacancy, because he said he wants to appoint justices who automatically will vote to overrule Roe v. Wade, the abortion decision in the early 70s. He wants to appoint justices who will sustain the Second Amendment, meaning gun rights. I don't think he knows exactly what the Second Amendment stands for, except he said that it has something to do with the right to bear arms, so therefore I suppose he thinks you could have a bazooka or a howitzer or any kind of weapon in your home. Maybe not a howitzer, because the Constitution says bear arms and you may not be able to carry a howitzer. So he and Pence is a great devotee of Justice Scalia. In fact, as governor in Indiana, he renamed I-69 the Antonin Scalia Thruway. And Pence said he said Trump will appoint justices who have the worldview and adopt the policies of Justice Scalia. And I don't think they really understand what Justice Scalia stood for or what his policies were. But nonetheless, it sounded good. It was good during the election campaign. Why they fastened on Roe v. Wade, which has been reaffirmed in the Planned Parenthood v. Casey case, and even most recently reaffirmed in the case where since Scalia died, involving abortion clinics in Texas, where they passed a law that you practically have to have a Nobel Prize to perform an abortion in Texas. And the Supreme Court said that's unconstitutional because it imposes a substantial burden on the right to abortion. So I don't know if they thought through any of these policies, but they are clearly looking for a justice to fill the Scalia seat who will vote to overrule Roe v. Wade, and other justices to fill additional vacancies that may occur during his presidency. Now, the immediate appointment will have little effect on the court because the immediate appointment will simply restore the 5-4 conservative liberal balance which existed when Scalia was around. In fact, the liberals may gain something from the new justice because probably, most certainly, the justice will never have the same intellectual heft that Scalia had. Scalia was the leader of the conservative wing on the court, and his death was a dagger to the heart, really, of the conservative movement because he wrote so brilliantly and his wit was so incisive and his pen was so barbed that he made his points in a way that it really left an indelible imprint on our jurisprudence. So that isn't really going to shift the balance so much. But what will shift the balance is that he'll undoubtedly appoint a young judge, someone in his 40s or 50s. So you will have a justice who potentially could serve for another 30 years. And that'll be true of additional appointments that may arise. Ruth Bader Ginsburg is 83. I suspect with a Trump presidency, she'll have to be on life support before she gets off the court. But it's possible that she will retire. It's possible that through illness or otherwise, there'll be another vacancy there. You have the average retirement age. Remember, they're all there for life. The average retirement age has been about 78. And you have Kennedy, who was 80. And you have Breyer, who is, I guess, 79. But I think Breyer is going to hang on. And I don't see why Kennedy won't hang on either. I don't think that they're going to retire. Breyer told me once that his father had told him when he was a very young man an overarching principle of public service, and that was always stay on the payroll. So I think he will always stay on the payroll as long as he can. So what does this all boil down to in terms of my book? My book was called Supremely Partisan, and I wrote it because I thought in the run-up to the election it might be interesting to see where the court had stood on various hot-button issues and which ones were likely to return to the court as time went on and how it might be affected by the presidential race. But 2016 has been a year of the unexpected. It is just amazing how the whole world seems to have stood on its head. François Hollande will be gone. Angela Merkel is fighting for her political life. David Cameron, gone. The EU goes on. It'll go on without Britain, and it may not go on at all. There's been a resurgence of nationalism and populism all over the world. We just saw it in Italy. So it should be no surprise that something was going to happen with the Supreme Court. Well, I had written my book, and I'd submitted it to the publisher, and I had a contract that said I couldn't make any revisions. And in February, I was down in Florida enjoying myself, waiting for the first galley to appear on my doorstep when my cell phone went off. And I looked at the cell phone, and it said Scalia had died in a hunting lodge. And I was absolutely aghast. And I called my wife, and I said, God, Scalia's died. And so she said, well, what does that mean? I said, what it means is I've got to go back to work. So I called the publisher, and there's some legal doctrines in the law of contracts. One is called frustration of purpose. And I invoked the doctrine of frustration of purpose. I said, Scalia's died. I've got to write something that contemplates Scalia's death, otherwise events will have overtaken us. Well, the publisher, being a reasonable man, said, yes, go ahead, write it. And then, of course, Obama was quick to appoint Merrick Garland. And Merrick Garland was a seasoned judge of great intellectual capability and terrific credentials, been a Supreme Court law clerk, and a law clerk to Judge Friendly on the district court, as was Chief Justice Roberts. And so I thought, my gosh, that's great, Merrick Garland. And then, of course, the Majority Leader McConnell said that the president, that the next justice will be elected by the next president, and the next Supreme Court justice will be elected by the American people, which is exactly what the Constitution doesn't say. It says appointed by the president and confirmed by the Senate. So there's a block on Merrick Garland. I knew he wasn't going to get anywhere. So I wrote that in the book with great confidence, and that came true. And the book came out. And then, of course, you had the election campaign with the two candidates fencing about what the new Supreme Court was going to look like. Would they overrule Roe v. Wade? Would they overrule Citizens United, the campaign finance decision? And that became a great issue in the campaign. Now, the Constitution of the United States, in Article 3, provides for a Supreme Court and such lower courts as Congress may ordain and establish. Article 1 of the Constitution gives Congress the power to organize the lower courts, and they did in the Judiciary Act of 1789. In terms of what are the powers of the Supreme Court, the framers really couldn't agree on whether to give the justices the power of judicial review. Jefferson was against it. He thought that was too much power. Hamilton, Alexander Hamilton's name is much in vogue recently, and Hamilton said that the court was really the weakest branch of government because they had no army. Hamilton knew a lot about armies. And they had no money. He was the first Secretary of the Treasury. He knew a lot about money. So so what did they do? They reached a compromise where they'd say nothing about what the powers would be of the Supreme Court, except it would be a court, it was supreme, and it would decide cases and controversies that might come before it. And then it defined what kinds of specific cases and controversies it might decide. Well, the Constitution was ratified. And in 1804, as you know, Hamilton was killed in a duel. He was killed by a Princeton alumnus. But in 1803, the year before he died, Hamilton's pal was the fourth Chief Justice of the United States. His name was John Marshall. And John Marshall wrote a very important decision. And that decision seized for the judiciary a power that exists nowhere in the Constitution, which is the power of judicial review, the power to declare acts of Congress unconstitutional, the power to declare acts of the president unconstitutional, the power to reverse the decisions of the state courts, of the lower federal courts. Their power became, and potential power at that point became enormous, and that's when it all started. And so as time went on, you had a Supreme Court deciding whether an African American was a citizen of the United States. You had a Supreme Court that was deciding whether Japanese Americans could be interned, a Supreme Court deciding when life began, and the Supreme Court even going so far as to elect the president. And I argue in the book that these decisions are essentially political because, as Scalia would say, the Equal Protection Clause and the Due Process Clause of the 14th Amendments, and he accepted that they would be incorporated and would apply to the states, are empty vessels. And he said, well, the liberal justices, and when I say liberal and conservative justices, it's very interesting that the conservative justices are those appointed by Republican presidents, and the liberal justices are those appointed by Democratic presidents. And the liberal justices on certain issues, more often than not, vote for outcomes that are consistent with those advocated by the Democratic Party. And the conservative justices, just the opposite. So when we say there's a 5-4 conservative majority, we're really saying that the Republican-appointed justices outnumbered by one the Democratic-appointed justices. Yet, we've seen a host of 5-4 decisions in the area of affirmative action, where the conservatives won out, at least mostly won out until the most recent case, which clouds the issue somewhat, in which they said that affirmative action violates the Equal Protection Clause, however benign, however well-intended. The Shelby County, Georgia voting rights case, and remember the conservatives have always said that they were strict constructionists and the liberals were flying blind, but in the Shelby County case, they struck down 5-4 Congress's determination that there were certain bad actor states which discriminated against blacks and suppressed the votes of blacks in the South. Well, strict constructionists would have said, well, we'll go with what Congress said. They had hearings, they made findings, but instead the court decided that we really had come to a post-racial society where blacks had made such great advances in voting and in holding office in the South, there was no longer need for a Voting Rights Act. Well, I think the record of the last election, which showed voter suppression in North Carolina, only demonstrates that the 5 justices were wrong. And then you go on to the gun case. Scalia was a textualist. He believed that the starting point is the text of the Constitution, and that you should also look to the understanding of society at the time that the text was ratified, and that you could also look to precedent, and that's how a judge should go about deciding a case. However, when you look at some of his decisions, like his decision in the gay marriage case, his decision in Lawrence v. Texas on the criminalization of homosexual sodomy, his statements at Princeton as to how he felt about homosexuality, it's quite clear that he made certain policy choices on bases not found in the Constitution, and then applied those policy choices to his decision. So it's true, as he said, that there is no basis for gay marriage in the Constitution. The Constitution doesn't mention marriage, and certainly doesn't mention gay marriage. And if you looked at the original understanding, and you'd asked any of them who were responsible for framing the language of equal protection whether they thought they were ratifying a right of decency for 2 people of the same sex to marry, they would have looked at you as though you were crazy. And as Scalia said in his dissent, how could there be a right in the Constitution that was not found by Oliver Wendell Holmes, Louis D. Brandeis, or Henry Friendly? It just escaped them. Well, he said that very sarcastically. But in any event, when they had the argument of the gay marriage case, his real feelings on the issue crept through because Scalia had said he believed in the devil. And in the course of the argument, some crazy man got up in the chamber of the Supreme Court and he began to scream and yell. And the marshals seized him and they dragged him out of the room. And as they were dragging him out of the room, he shouted at the top of his lungs, "You're all going to roast in hell for this." And Scalia leaned over the bench and he said, I find that rather refreshing. He believed he was an originalist. And there's a lot to originalism because these 9 people there are supposed to be lawyers. They're not supposed to be moral philosophers. They're not supposed to be ethicists. They're supposed to interpret language. And they're supposed to do it in a judicial, professional way based on decided cases and based on what the plain meaning is of the language. The problem is often the plain meaning is not obvious. And often the meaning of terms, as I said, such as due process or equal protection, may have myriad applications. And then the question which I was asked in England is, how can you possibly govern a society with a document that was created in the 18th century by white Anglo-Saxon Protestant men who wore wigs and were in knee breeches? Well, the answer is that you've got to look at the values that they were saying. So when we get into DNA and the internet and GPS, how does the Constitution, the Fourth Amendment, searches and seizures, how does all that apply or how do the values of an 18th century society apply to that? How does flag burning, how does language that says that Congress shall not abridge the freedom of speech, how does that apply to burning the flag? Is burning the flag speech? Well, it's symbolic speech. Scalia thought so. And actually, at the time of the Constitution, it was perfectly possible to burn the flag. It just wasn't a demonstration then of political expression. But the fact is, the First Amendment, as he saw it, and he was absolutely correct, guarantees freedom of expression. And the flag burning was an aspect of free expression. So one other point that I cover in the book, and it's kind of an interesting point, is identity politics. When Scalia was around, the court consisted of 6 Catholics and 3 Jews, 100% minority, in a court that had 112 justices since 1789, of whom 89 were white Anglo-Saxon Protestant males. They didn't do so badly. I mean, they decided Brown v. Board of Education, and with the exception of Brennan, who was a devout Catholic but voted with majority in Roe v. Wade, they decided Roe v. Wade. Felix Frankfurter said that the ethnicity or the religion of the justice really doesn't mean anything in terms of how they decide cases. They decide cases on the basis of the Constitution. Well, that hasn't always been the case. Ginsburg disagreed with that. She felt a Jewish justice looks at the world a little differently, looks at the underdog a little differently, looks at the outsider a little differently from a white Anglo-Saxon Protestant justice. She felt that a woman looks at the world a little differently, and certainly Sotomayor would have agreed with that. But you have the question of why the appointing authority thought that it was important to appoint a justice of a certain provenance to the court, and what the president's expectation was in appointing such a justice. Now, when you have Clarence Thomas was appointed by George H.W. Bush in 1991 to replace the legendary Thurgood Marshall. And it was thought that there should be an African-American seat on the court, just as there had been, many people don't know this, a Catholic seat and a Jewish seat. Most people know there was a Jewish seat. That lasted 53 years. And we can talk about that for a minute, but Clarence Thomas, having been appointed and having taken his seat on the court after a vicious confirmation hearing, proceeded to vote against black interests every time the issue was presented. And it wasn't only on his opposition, his philosophical opposition to affirmative action or other issues. Most recently, there was a case arising from Georgia where blacks were systematically challenged off the jury by the prosecutor in a capital case which involved the death penalty. And the justices 8-1 voted that was unconstitutional under the Batson case because they had unearthed something which is very rarely unearthed. There were documents in the prosecutor's file that the defense had obtained, which showed beyond any doubt that the prosecutor had used racial criteria in challenging blacks off the jury. Yet Thomas thought it was harmless error. Now, how could he possibly explain a result like that in terms of the Constitution, in terms of originalism, or in any other respect? The Jewish seat, which lasted 53 years, went on, starting with Brandeis in 1916. He faced bitter confirmation hearings himself. The leaders of the Bar Association wrote letters to the Senate Judiciary Committee. It's such a Byzantine that we have. And they said, Louis D. Brandeis is unfit to be a justice of the Supreme Court of the United States. Well, he was narrowly approved. after a bit of confirmation hearings. He did not attend the hearings. And then there arose a custom of presidents to appoint a Jewish seat, a Jew to fill every Jewish seat that became vacant, and there was only one. That continued until 1997 when 1967 when Nixon, when Fortas resigned after a scandal, and Nixon was to appoint a justice, and he appointed Harry Blackmun. And this is on the White House tapes. John Mitchell, who was the Attorney General, came to the Oval Office, and he said, "You can't appoint Blackmun, Mr. President. He's not a Jew. This is a Jewish seat." And Nixon said, "I'm appointing Blackmun." Because Blackmun disappointed him a little because he was the author of Roe v. Wade. But he said, "I'm appointing Blackmun." So Mitchell said, "Well, Mr. President, when are you going to appoint a Jew?" And Nixon said, "After I'm dead." So that was the story on the Jewish seat. So in any event, we have identity politics on the court, and that will figure undoubtedly in the appointment of the next justice. We have the question of ideology and politicization of the court. You could not imagine a more politicized appointing process than what we've just seen. And undoubtedly, as we read these opinions and see what goes into them, we find that what goes into them is not legal interpretation. What goes into them is preferred policy choices, which are based on the ideology, perhaps the life experience of the individual justices. So I think I've said my piece, but I'd be very happy to answer any questions that you have.
Okay, so we'll take some questions now from the audience. Yes.
So the sitting president should appoint the Supreme Court justice in the case of a vacancy, like a death. Mitch McConnell is defying the Constitution and not allowing this to happen. Can we impeach Mitch McConnell?
Well, the answer is yes, he could be impeached. You'd have to have a reason to do it, not that.
I gave you that.
I think that, the sad thing is that our friends Hamilton and Madison contemplated exactly such a politicization. And a president undoubtedly will appoint justices in accordance with the president's preferred policy choices. And the Senate will look at criteria and more so, other than is an honest justice, is an honest judge with a good record and has gone to the right law school and had a good clerkship.
Like the one that was appointed.
Like the one that was appointed, but they'll also look at other criteria, and they're entitled to do that as well. And they're also entitled nothing requires them to hold hearings because the Constitution says they make the rules, and the majority leader is within his rights, most probably, not to hold hearings and to allow the process to be stalled until the election. It's a crying shame.
Yeah, it's not patriotic.
Well, who says they're interested in the best interest of the country as we see it?
Clearly they're not.
They're interested in politics. Yeah.
It's not a dialogue.
Oh, sorry.
Yeah.
I apologize to everyone.
Anyway, I think you have my answer.
All right, thanks.
Yes, sir.
Yeah, yes.
I've heard Justice Breyer say on several occasions that the decisions of his conservative colleagues, I think specifically with respect to Bush v. Gore, were not political. Can you explain what you think he meant by that?
Can't explain what I think he meant by that because it was clearly political. The 5 Republicans voted to stop counting of votes in Florida, and it was is generally regarded by legal scholars as the most partisan decision that the court has made in recent years. It's a decision which Sandra Day O'Connor, who voted with majority, later said she regretted, and she was heard to say at a party, "This man Gore can never be president." So she clearly had a view about the outcome. I think there is, if you look at the law, there was no irreparable harm in the state of Florida continuing to count votes. although who knows what the outcome would have been. The New York Times afterwards counted all the votes in the state, and it appeared that Bush did win the state. But voting has become a very dicey process these days.
Yes.
Would it have helped if judges would be appointed to a limited term, such as 10 or 15 years?
The Constitution says they're there during their good behavior, which means that unless they retire or die or are impeached, they will continue to serve. It's interesting that only one justice has ever been impeached, and that was a justice named Samuel Chase, who was appointed by George Washington in 1802, and he was impeached because Thomas Jefferson thought he was too partisan, but the Senate refused to convict him, and he was not removed from office.
Yes.
That was my question.
Oh, okay. Yes.
If, assuming that the new Supreme Court would work to overturn Roe v. Wade, and assuming they want to do it quickly, how quickly could they do it, and what would be the process?
Well, I think if you had to wait for the issue to come up from various states, because there are various procedures, and particularly in southern states, that a woman must be given a sonogram before she can have an abortion, and that it has to be explained to her exactly what the implications are. Vice President-elect Pence thinks that they should hold a funeral for every fetus that's aborted, and it should be explained to them the nature of the funeral service, and they can make all the plans. And those cases will come up slowly. I think the present court would, even if there's another conservative justice would, who wanted to overrule Roe v. Wade, would say that that places a substantial burden on a woman's constitutional right to an abortion, at least when the fetus is non-viable, which seems to be the present state of the law. However, there is a bill in Congress which, if enacted, would provide that abortion would be criminalized or would be illegal after 20 weeks all over the country. Now, if that happens, it will of course be a challenge, and that would reach the Supreme Court more quickly.
Yes.
Do you think that 5-4 decisions eliminate the concept of stare decisis?
Well, not necessarily. I think 5-4 decisions, 6-3 decisions raise the question as to whether they're not partisan decisions. And you have to look at the extent to which they rely on prior decisions, or the extent to which they overrule them, in order to determine whether it's a partisan decision or whether it was a reasonable disagreement about the interpretation of the law. Now, you get Brown v. Board of Education in 1954 overruled Plessy v. Ferguson, I guess 58 years later, and holding that separate facilities and schools were, or anywhere really, were inherently unequal. Now, everyone agrees that it was correct to overrule that prior decision. It was malicious and was not sustainable. But then when you get cases that, for example, in the abortion area, where the Stenberg case held that it was unconstitutional to have a statute where a woman could not get a late-term abortion unless the statute provided that an exemption where it was necessary for the health of the mother. And then when O'Connor retired and Alito came on, in the Gonzalez case, they held just the opposite on identical facts. Each case was 5-4, and you would have to say that that was a partisan decision.
If I could just follow up on that, putting aside how we got to an 8-person court, is it so bad to have an 8-person court so that, you know, the majority would require something like 5-3?
Well, of course, in 1789, when all this got off the ground, there was a 6-person court. So it wasn't always an odd number.
It is within Congress's purview.
It's all within Congress's purview, and the president could refuse to fill the vacancy. Of course, 2 of the justices, I think Kagan and Sotomayor, say you should have 9 because if the court is deadlocked 4-4, then the decision has no precedential value and the ruling of the lower court is left undisturbed. So that means that the Supreme Court is basically dealt out of the equation. And so you don't want to have a court there that really has no power to act. So with an even number, it's more possible that you'd have a deadlocked court.
This idea of settled law, it's always been fuzzy to me. Can you define what constitutes settled law?
Well, settled law is unsettling, but I mean, there's certain things that have never received anything other than their classical interpretation. The Constitution says there should be 2 senators from each state. No one's ever challenged that and said, well, it really means 3. But then you have cases that precedents where the court doesn't even take the case because the principle has been established and enunciated and then affirmed and reaffirmed again and again. An example of that in my mind is Roe v. Wade, where with Planned Parenthood and other cases, they have declined to overrule Roe v. Wade, and they have refused to even hear similar cases that sought to challenge Roe v. Wade. So I would say Roe v. Wade is settled. It's a super precedent. And what's interesting is that when it was decided, most Catholics believed that abortion was a sin. The polls showed that most Catholics did not believe it should be criminalized and did not believe that other people should be penalized because they wanted an abortion. They believed it was a personal decision, most Catholics in America. It was only when Karl Rove got into the act and decided that there were too many Catholics who were voting Democrat, and there were evangelicals who didn't like abortion either, and Orthodox Jews who didn't like abortion, who ought to be voting Republican. And so they said, well, how can we make sure that they will vote Republican and we can have Republican presidents start appointing conservative justices who don't like abortion rights? So you appoint someone like Alito, who was the deciding vote in the case that I talked about, the Gonzalez case. And of course, he appeared before the Senate, and they said, well, Judge Alito, how do you feel about abortion rights? He said, oh, can't discuss that. That's an issue that might come before me if I'm appointed to the court. Of course, his mother left the hearing and turned to the reporters and said, as you know, of course he's against abortion. I know my son, he's against abortion. So that's where you get this kind of pernicious result where they appear to be and are in fact voting in accordance with policy decisions that they've made.
Do you think that the partisanship in the circuit courts of appeal is as great as it is at the Supremes, with the Supremes?
I think much less so, because first of all, most of the issues that these judges decide involve patents or ERISA or securities regulation, and we haven't even gotten into how partisanship might affect their approach toward regulation or toward business or toward consumer rights or stockholders' rights, and it does carry through there too. But I think less so in the Court of Appeals, because after all, the Supreme Court is the court of last resort. So if you don't make policy choices there, where are you going to make them? We had a great Justice, Robert Jackson, who reflected on the role of, he's probably the greatest writer to be on the court. Interestingly enough, he didn't finish law school. And, he had this wonderful statement where he said, we are not final because we're infallible. We're infallible because we're final.
Yes.
You mentioned that there should be a seat for the tradition. There should be a seat for an African American, for a Jew, and for a Catholic. There's no seat now for a Protestant, I believe. These issues, are religious, abortion, etc. Isn't it time they reserve a seat for the Protestants also?
Well, there are nine seats potentially for Protestants, so that just for a president to appoint one and for him or her to be confirmed by the Senate.
No.
But, you know, when I was a lot younger, I wasn't always this way. When I was a lot younger, in New York, there was a mayoralty election, and it was Lefkowitz, Gilhooly, and Fino against Procaccino, Beam, and O'Connor. That's the way people made tickets. I mean, and we live in a multicultural society, and there's a certain degree of power sharing and log rolling. And I like to think judges are appointed on the merits, and the presidents are colorblind, but they're not. And you saw how Nixon felt about the Jewish seat, and I think that had Garland been seated, you would have then had 4 Jews on the court and 5 Catholics. And so I think something ought to be done to have perhaps a little more diversity weighted toward the Protestants. I'm for that.
No, I was wondering, in the modern era, in a case that was really significant, that was going to be a split vote, can you think of, you know, 1 or 2 dramatic instances where a justice voted on legal principle in contrast to his political inclinations? And is there any particular judge in a post-war era that you would give high marks for voting more consistently on legal principles?
Yeah, well, I don't know about on legal grounds, but you take I mean, you start with the Korematsu case and the dissents, but interesting enough, the dissent of Jackson, the dissent of Murphy, because they believed strongly in individual liberty and civil rights. Interestingly enough, voting with the majority were such stalwart conservatives as Hugo Black and William O. Douglas, who of course liberal justices, and they felt that the military, that the courts ought to defer to the military in matters of the internment. The man who organized the Japanese internment was a prosecutor from California named Earl Warren. Eisenhower appointed him, expecting he'd be a conservative. He turned out to be a very liberal justice who found all sorts of new rights in the Constitution, who believed in a living Constitution. And there was a wonderful statement he made in the Trope v. Dulles case that the meaning of the 8th Amendment, which is the cruel and unusual punishments clause that applies to everything, is to be drawn from the evolving standard of decency that marks the progress of a maturing society. Well, Scalia threw up his hands at that. He said it made him want to throw up because he said, first place, he said doesn't know what the evolving standards of decency are, and he doesn't want to know. And secondly, he said it's not found in the language of the Constitution. You're just giving the judge discretion and license to find a right here and a right there, which they'll extinguish next year. And so he didn't like that very much.
Yes.
There are other examples.
Speaking of cruel and unusual punishment, where do you see the death penalty going as it relates to this Supreme
Well,
Court?
I'm glad you asked about the death penalty because I left it out. The Constitution clearly recognizes the death penalty. The 5th Amendment of the Constitution says no one shall answer to a capital or otherwise infamous crime without indictment of a grand jury. And it says in the same amendment that no one should be deprived of life, liberty, or property without due process of law. And Scalia used to say, when it says deprived of life, you know goddamn well what they mean. Scalia was a staunch upholder of capital punishment. He thought it was authorized by the Constitution. And he said if you look at the cruel and unusual punishments clause, you have to look at what was cruel and what was unusual in 1791. And that's the way he interpreted it. So that in 1791, they hanged people for stealing horses. In 1791, if you kissed your wife in public on a Sunday, they'd throw you into the stocks. I think most judges would say that today that's cruel and that's unusual. He saw it somewhat differently. He said it's stupid but constitutional. And I'm sure if it ever came up, which it wouldn't, he would say that it wasn't right. But he wanted to say that to illustrate his originalism. Now you have 2 justices Ginsburg and Breyer, who've thrown up their hands and they say that the death penalty is unconstitutional. And they say one of the reasons is that now with DNA testing, we found that a lot of the people on death row are innocent in fact, and if they were executed, they would be deprived of life without due process of law. Then you have other justices who've gotten into this morass of how cruel and how unusual with lethal injections with various chemicals and how long it takes and does the defendant suffer. I mean, causing Justice Blackmun in one of the cases to throw up his hands and he said, I'm not going to decide any of these cases anymore because I don't want to tinker with the machinery of death. And so I think there's little prospect that they'll hold the death penalty unconstitutional, certainly not in the next 4 years or 8 years. But someday, they'll decide and this was anathema, and this kind of thinking was anathema to Scalia, but based on what is done in other countries and based on what is done by the various states, because more than half the states now either have outlawed the death penalty or don't, or haven't executed within the last 10 years. The federal government still has a death penalty, and probably Tsarnaev in Boston will be executed, so there will be a federal execution.
Yes, right here.
Do you see any ways of reversing this trend, or do you think this increased politicization will just continue in the future?
Well, I think given the results of the election and the potential that he'll appoint 3 or 4 justices who will automatically do this, that, or the other thing, I think that I don't think it's going to be reversed, and that's going to govern the direction of the court for the next 30 years, because he'll appoint young justices.
So to what extent, I guess, is there precedent for a president actually prescribing a positive list of positions on policies, but also broader constitutional questions as kind of conditions for eligibility to be considered? And then I guess as a follow-up, is this a unique moment, unique to Trump, or is this going to become the new standard for the process here? This explicit, do you agree with X, Y, and Z, and will you do A, B, and C if I appoint you to the bench?
Well, as Chief Justice Warren said, there's an evolving standard of decency, but I think Trump has clearly said he's going to use the litmus test. Now, the president is entitled to use a litmus test. He may say he doesn't, Nixon said he didn't want to appoint a Jew. He may say he's entitled to do that. He may say he doesn't want to appoint a Catholic. And he may say he only wants to appoint someone who will automatically overrule Roe v. Wade. Now, it's for the Senate. This is our check and balance, because really our liberty is more protected in the basic framework of the Constitution than it is in the Bill of Rights. All sorts of banana republics have bills of rights, but the fact that these very, very smart men who were the framers, Madison, the Princeton graduate, and Hamilton went to Columbia and tried to get into Princeton. I don't think he got in. That they saw that the way to protect us from a man on horseback, from a tyrant, was to have a separation of powers and a system of checks and balances. And so, therefore, the Senate has the right to advise and consent to the nominee of the president. And you will find senators, including Republican senators, I think, who are going to give him a lot of pushback on appointments to the Supreme Court. So I don't think the trend necessarily will continue. I don't think the rhetoric of the campaign will necessarily carry over, but I think he does have a Republican conservative base he has to mollify with the next appointment to keep the 5-4 division of political power. But I don't think he's going to appoint Merrick Garland.
Yes, right here.
Do you think the Electoral College will ever be changed?
Well, that's on the Constitution.
Right.
And a lot of these questions are whose ox is being gored. So had the election gone the other way with Hillary winning in the Electoral College and losing the popular vote, a lot of people would have said, no, we need the Electoral College because that really prevents a populist from being elected, a know-nothing, and from our political history. And so I don't think it's going to be changed. I think it can't be changed mostly because it takes 2/3 of the Congress and 3/4 of the states to change it under the Constitution, and you're not going to get 2/3 of the Congress or 3/4 of the states to agree on anything, even what day of the week it is. And so I don't think it's going to be changed. And it was intended by Hamilton and Madison to filter, and there are other examples, to filter the government of the United States from the people. And you see that, it wasn't until the early 20th century that we had the direct election of senators. Because the senators were elected by the state legislatures. And that's because the states owned the Senate. And it was thought that it would be possible, if there was direct election of senators, that the states would be tyrannized by the federal government. Now we have direct election of senators. I don't know that it's an improvement.
As a follow-up to that, and this is an inherently subjective question, but do you think that things would be better, or how would things be different if it were easier to amend the Constitution? Because as you say, it's incredibly difficult at the present, right?
Well, Scalia would say that every time the liberals vote, they're voting to amend the Constitution. So, yes, it's sort of taught in the law schools and in every constitutional law class that I know of that you don't tinker with the Constitution. It's not a good idea. And you find that following the Civil War amendments and direct election of senators, and then we had prohibition, and then we repealed prohibition, and then we gave women the right to vote. But, other than those instances, we really haven't done much except for the technical nature in amending the Constitution. There have been 27 amendments. I guess, but the 13th, 14th, and 15th were the Civil War amendments, and that was really a key turning point in making the Bill of Rights applicable to the states.
Yes.
Oh, and to answer your question, I don't think it should be made easier.
Recently, Chief Justice Roberts voted unexpectedly, and everyone in the Medicare or the
Obamacare.
The Obamacare, yes. And there was a case where he went against his politics. It was, I wish you'd comment on reaction to that.
I think he went in accordance with his politics. I think as a legal matter, his votes could not be explained because he did hold that it violated the Commerce Clause. The mandate violated the Commerce Clause. The Congress didn't have the power to order you to eat broccoli or to buy health insurance. And he said that that was a penalty. However, he said I'm sorry, for purposes of the standing issue, he said it was a penalty, and so therefore there was standing to raise the question. And for purpose of the Commerce Clause issue, he said it was a tax, and since the Congress didn't have the power under the Commerce Clause, it did have the power under the Taxing Clause to impose a tax, and this was a tax. Obviously, it had never been intended to be a tax, but I have another explanation for why he voted the way he did. He voted the way he did because when he testified before the Senate, he said the one period that he viewed as a dark era in the history of the court was the Lochner era. And remember, that started in the early 1930s, starting in the early part, actually, of the 20th century. The Lochner case came up from New York, where the New York State Legislature tried to limit the hours that bakers could work and to have better working conditions. And the court struck that down as unconstitutional, as violating the Due Process Clause of the 14th Amendment. And there then evolved a succession of cases which went into the New Deal, where the court, again and again citing Lochner, would strike down New Deal legislation and say that it violated freedom of contract and it violated the due process clause. The court was in disrepute. Franklin Roosevelt said that they were making the law the way legislatures do. They were not interpreting the law. He wanted to pack the court. He wanted to increase the number of justices to 15. For every justice over 70, he said they were grumpy old men, he would appoint another justice. Well, the whole thing was brought to an end when one justice, who had always voted with the conservatives, voted with the liberals, and it was 5-4, and they sustained a piece of New Deal legislation. That was called the switch in time that saved 9. And Roosevelt didn't care, because then they started to retire, and he got to appoint 9 justices to the court. So the court packing bill that he presented to the Senate, to a Democratic Senate, was actually dead on arrival. And in retrospect, historians have said that impaired the independence of the judiciary. But getting back to your question, Roberts said that he hated the Lochner era. He hated the Lochner case. He didn't want the court to be politicized. He saw himself as an umpire, remember, calling balls and strikes. He said no one goes to the ball game to see the umpire. Well, I think he felt that here you had an eponymous piece of legislation, a signature piece of legislation of a new president, and it was supposed to be a great achievement, universal health care, which no other president had been able to achieve, and he could not see the Supreme Court as striking that down, and that's why he decided what he did.
Thank you.
When discussing the politics of the Supreme Court, we often talk about how they vote and what they do, but what about choosing which cases they hear and which cases they'll vote on? Because of course they can't set a precedent if they don't hear it first. Do conservative justices actually just ignore some cases and let the local level ruling stand more often than liberal justices, or is that just not the case?
Well, I think when these cases arise, often you can find a case already decided to support almost any proposition that you want to. So we look at the Supreme Court. Your politics professor looks at the Supreme Court based on the outcome, not how they got there, not how well they applied the prior precedent or how well they distinguished the prior precedent, but on the outcome. Are they for voting rights in the South? Are they against it? Are they for abortion or not? Are they for guns or aren't they? They don't. And it really is sort of a footnote to history, what's in the footnotes to the opinion and the cases that they cite. So, but to answer your question more directly, I think judges will look for cases, because they're advocates, that support their positions, and they will ignore cases that don't support their positions. I once said to a circuit judge, what do you do when you disagree with a case that's been decided, and it's foursquare, it really blocks you from reaching the result you intended? He says, very simple, we ignore it.
Yes. Of the current court, which judge would you say is the most partisan?
On the left, Ruth Bader Ginsburg, unquestionably. On the right, probably Clarence Thomas, because he is an originalist. He believes in natural law and believes that if the right isn't found in the language of the Constitution, the right doesn't exist. And he's prepared to overrule any decision which he feels is contrary to the Constitution of the United States as he interprets it. And then you have shades in the middle. Yes.
What do you think about the practice in the state level where people elect judges?
Bad. I think elected judges are subject to partisan politics, political contributions, and corruption. They come up through the political process to a much greater degree. I think our federal judges are vetted and screened, and they're people of great intellectual stature. And it's for that reason that they're able to be appointed and be confirmed by the Senate.
Time for about one more question.
What would you change in the confirmation process?
I think the confirmation process is so Byzantine, and it is so much a case of senators trying to grab headlines, and and that's really what I think it's terrible. It's deplorable. I hate that word, but but I think there's nothing to do about it, and I think it'll always be the case. The senators are lawyers. Lawyers like to vamp in front of the cameras and posture, and so you have this hateful process. And hopefully, because of backroom deals and whatever, someone good gets through. Remember, Scalia was confirmed unanimously.
Well, join me in thanking